my name's Becca Hogan. I'm an associate here at Clyde & Co, and I've been here for 6 years. I've set out on this slide an overview of the presentation I'm going to be giving today, covering an overview of the UK Bribery Act and the US Foreign and Corrupt Practices Act. So, the Bribery Act commenced on the 1st of July 2011. It does not have retrospective application. However, the general offence of bribery was illegal prior to the introduction of the Bribery Act, and I've set out on the slide here the previous law governing that. The Act introduces a new strict liability offence of failure by a commercial organisation to prevent bribery, and the Act was introduced to make it easier to prosecute bribery. It was intended to crack down on bribery, as bribery costs the UK £30 billion a year and considerably more globally. The Act is therefore designed to have maximum deterrent effect. Bribery is not defined in the Act, however it can be described as a financial or other advantage intended to induce another person to perform a relevant function improperly. The Bribery Act covers all aspects of bribery, not just foreign public officials like the Foreign and Corrupt Practices Act. The two general offences of bribery cover both giving and receiving of bribes, known as active and passive bribery. The general offences are predicated on people performing relevant functions. Section 3 of the Act sets out the relevant functions or activity to which a bribe relates. It must have a public nature, be connected with a business, or on behalf of a body of persons. The Act applies to bribery outside of the commercial sphere, for example, attempts to influence decisions by local authorities or elected representatives on matters such as planning consent, school admission procedures, or driving tests. A requirement of the general offence is that someone is induced to perform a function improperly. The Act is slightly backwards in that it tells you what proper performance is, such as acting in good faith, impartially, and in a position of trust. And then it says that improper performance is something contrary to that, so it has to be in breach of an expectation of proper performance. The expectation is judged on the standards of a reasonable person in the UK. Section 6 of the Act sets out the offence of bribery of a foreign public official, and I've set out on this slide who is deemed to be a public official, such as someone who holds legislative, administrative, or judicial position. The payment can be made by the company or by a third party on behalf of the company. Unlike the general offences, there is no improper performance requirement. It merely has to be done with the intention of obtaining or retaining a business advantage. This provision can be contrasted with the Foreign and Corrupt Practices Act approach to facilitation payments, which are unofficial payments made to public officials in order to expedite the performance of a routine function. They are sometimes referred to as grease or speed payments. Facilitation payments are expressly permitted under the US Foreign and Corrupt Practices Act, whereas under the UK Bribery Act they are expressly prohibited. The guidance notes that small payments are likely to result in only a nominal penalty, whereas large or repeated payments are more likely to attract a significant sentence. Section 7 introduces a new corporate offence of failure to prevent bribery. For instance, where an associated person of a company is deemed to have committed one of the general offences on behalf of that company, then the company may itself be liable for failure to prevent bribery. Associated person is given a very wide definition of performing services on behalf of, so that will include employees, agents, subsidiaries, third parties, vendors, and other agents of a commercial organisation. It is a full defence to have in place adequate policies and procedures to prevent bribery. However, given that the instances in which a company is prosecuted for this will be where bribery has occurred, the fact that bribery has occurred may be enough evidence to say that the policies and procedures were not adequate. Procedures may only be deemed adequate where they catch bribery before it has occurred. It may, however, be possible to argue that the associated person was acting contrary to the organisation's policies and procedures, and that may be sufficient. The Act introduces an element of director liability, where a director or a senior manager is deemed to have consented or connived with one of the general offences of bribery, then they will be deemed to be guilty of the offence and liable to be prosecuted and punished accordingly. The director or senior officer must have a close connection with the UK in order to be prosecuted under this offence. I've set out here a summary of the defences available. As noted earlier, in relation to the corporate offence of failure to prevent bribery, it is a full defence to say that you had adequate policies and procedures in place. For directors, they will only be liable where they have a close connection with the UK, which will typically be where they are ordinarily resident here or a UK citizen. A defence to the general offences of bribery is available where it is expressly permitted by the local law where the bribe was paid. Local law amounts to any written constitution, legislation, or published judicial decision. In addition, the guidance recognises that there are circumstances in which individuals are left with no alternative but to pay a bribe in order to protect against loss of life, limb, or liberty, and the common law defence of duress will usually be available in such circumstances. The scope of the Act is very wide and it is extraterritorial. This means that companies will be captured even where they have a presence in the UK and the bribery occurs outside of the UK for the benefit of the UK entity. UK courts may have jurisdiction irrespective of where in the world the acts or omissions which form part of the offence were committed. I've set out here a summary of the penalties under the Act. The unlimited fine and the lengthy prison sentences show that they really mean business in cracking down on bribery. In terms of prosecutions under the Act, the director of the relevant authority, which will be either the Serious Fraud Office or the Director for Public Prosecutions, will be required to give permission before a prosecution can be initiated, and it has to be deemed to be in the public interest. Under the Act, the Ministry of Justice was required to publish guidance in relation to what would be deemed to be adequate procedures, which, as noted earlier, is a full defence to the corporate offence of failure to prevent bribery. The guidance sets out 6 principles which underlie adequate procedures. Proportionate procedures means that the action a company is required to take should be proportionate to the risks it faces and to the size of the business. Top-level commitment is essential. Senior officers and directors must enshrine a top-down commitment to compliance culture. The risk assessment principle ties in with proportionate procedures, and you should think about the bribery risks faced by the company, such as market, industry, and country risks. Due diligence means that you should know exactly who you are doing business with. The definition of associated person is very wide, and therefore you should take care to ensure that your business partners are not committing bribery, as this may later be deemed to have been acting on the company's behalf. Communication means ensuring that all employees are fully aware of the company's anti-bribery policies and procedures and providing training on this as appropriate. And finally, monitoring and review. This principle requires companies to carry out periodic reviews of their policies to ensure that the policies are working and to plug any gaps where necessary. Gifts and hospitality are considered to be a potential risk area for the giving and receiving of bribes. Whilst it is not expressly prohibited by the Act, the more lavish the hospitality or expenditure, the greater the inference that it was intended to encourage or reward improper performance or to influence an official. Lavishness is just one factor that may be taken into account in determining whether an offence has been committed. The full circumstances of each case would need to be considered, and other factors may include that the hospitality or expenditure was not clearly connected with a legitimate business activity, or it was concealed. It is recommended to set up a gifts and hospitality register which provides a record of gifts given and received over a nominal amount. It is also advisable for high-value gifts or hospitality to be risk assessed and authorised in advance. Gifts and hospitality should be in line with the company's business and proportionate to the types of business done. For example, travel expenses, in order to demonstrate types of goods or services to clients, can be reasonable. On this slide, I've set out some of the policies and procedures you should consider implementing in order to meet the adequate procedures test. This could form part of one or numerous policies, or could be added to existing policies where relevant. You may already have a number of these policies in place. The key point is to document everything and to create an audit trail. If it is not documented, then it didn't happen. On this slide, I've set out some of the points to consider when doing due diligence on third parties. In terms of high-risk countries, Transparency International has a free online corruption perceptions index which provides a very useful guide to the risk ranking of countries. Ghana is ranked 63 out of 175 on this index. To put this into context, Ghana is in the same bracket, scoring 40 to 50, as Greece, Italy and Saudi Arabia. By comparison, the UK is in the 70 to 79 bracket, along with the USA. Turning to some case studies, the case of BAE Systems came before the implementation of the Bribery Act, but it is nonetheless informative. BAE Systems pleaded guilty to an offence of failing to keep accounting records sufficient to show and explain the transactions of the company. The offence related to payments of $12.4 million paid by two of its subsidiaries in Tanzania. A guilty plea by BAE followed a settlement agreement between the company and the Serious Fraud Office. The agreement included a provision for BAE to repay £30 million for the benefit of the people of Tanzania. In return, the SFO agreed to drop all of its investigations into BAE and not to prosecute further. In parallel, the US Department of Justice investigated BAE in relation to the sale of fighter jets to Saudi Arabia. BAE was fined $400 million in that case. Only 12 individuals have been prosecuted under the Act so far, and I've set out here some of the cases. In the unfortunate case of Yang Li, a failing student who attempted to bribe his university tutor by placing £5,000 in cash on the table, the tutor refused to take it, and when he got up to leave, a firearm fell out of his pocket, so he was charged with both bribing and carrying a firearm. 4 men have been charged in August 2013 under the Bribery Act by the Serious Fraud Office, and that represents the first charges by the SFO. The men were charged with making and accepting financial advantages, and the case is ongoing. Turning now to the US Foreign and Corrupt Practices Act. It is an offence to offer, make or authorise the corrupt payment of money or anything of value to foreign officials. It is also an offence to fail to keep accurate books and records or to have adequate accounting controls. The FCPA was enacted for the purpose of making it unlawful for certain classes of persons and entities to make payments to foreign officials to assist in obtaining or retaining business. The FCPA applies to foreign firms and persons who cause, directly or through agents, an act in furtherance of a corrupt payment to take place within the territory of the United States. It also encompasses issuers, i.e. companies that issue shares in the US or file reports with the Securities and Exchange Commission. The Department of Justice has issued a 130-page resource guide to the FCPA, which is available from its website, and I provided a link to that at the end of the presentation. The case study of Straub demonstrates how far-reaching the jurisdiction of the FCPA is. Here, a foreign individual was caught by virtue of being an executive of a company whose shares were traded on the US exchanges. As noted earlier, there is a difference between the UK Bribery Act and the FCPA, in that the FCPA provides a defence or exception to the rule regarding facilitation payments, whereas the UK Bribery Act expressly prohibits it. There is a further defence available which is comparable to the Bribery Act, where payments are permitted by local law. The Department of Justice, however, says that the defence will be limited because local laws probably won't allow corrupt payments. Bona fide expenditure, including travel and accommodation, are also permitted, but not entertainment. There is a procedure in the US where you can seek an opinion from the Attorney General regarding a proposed arrangement, and they will then determine in advance whether that will fall foul of the Act. And I've included a link to other opinions on the slide there. Turning to some case studies, in the case of Weatherford International, it was fined $253 million and disgorged profits of $65 million for a lack of sufficient internal controls, which created a corporate environment where illegal bribery was acceptable. Weatherford made improper payments to government officials in Africa through a joint venture in order to secure sensitive information about its competitors. It paid bribes to foreign government officials. It awarded $15 million in funds to a distributor, and it paid $1.5 million in kickbacks to the Iraqi government in relation to the United Nations Oil for Food programme. In the case of Mary Benny, it was fined $88 million by the Department of Justice. In March 2014, it entered into a plea agreement with the Department of Justice in relation to paying bribes to high-ranking Indonesian government officials to secure a lucrative power contract. The bribery occurred over a period of 7 years. Mary Benny worked with a Connecticut company to bribe Indonesian officials, and it conducted some of its business in the US and was therefore caught by the Act. As part of the plea agreement, Mary Benny agreed to ensure that its directors and senior management would provide strong, explicit and visible support and commitment to its corporate policy against bribery and corruption. It also agreed to develop a policy against violations of the FCPA and other applicable foreign law. The requirements of the DOJ were helpfully set out in an annex to the decision, and that can be used as a guide to what is expected of companies. I've included a link to the decision on the slide there. One of the requirements was that Mary Benny would introduce a third-party policy. The definition of business partner can be very wide and can extend to agents, intermediaries, consultants, representatives, distributors, contractors, and joint venture partners. It is essential, therefore, to carry out full due diligence on third parties and ensure that there is a full audit trail. This will be necessary to demonstrate that the risks were fully assessed. It is not good enough to say that the company considered the risks orally or in a meeting without a record of that. Evidence of those considerations will be required. The Department of Justice required that business partner commitment to anti-corruption laws be enforceable by contract. It is important that high-level standards of compliance are enforceable as against business partners. That will then protect your company if your business is later deemed to be non-compliant. Further examples of policies and procedures you should consider implementing are set out on this slide. These were also required as part of the Bribery settlement agreement. I've set out here some free online resources that provide a wealth of information, some of which I've already referred to. So, in conclusion, it is clear that from both the UK and the US regime, the consequences of breaching those laws can be extremely expensive and could result in criminal, regulatory and civil penalties, in addition to personal liability and reputational damage. You should know who you're doing business with and ensure that they have high levels of compliance, particularly given the extraterritorial scope of the UK and the US anti-corruption laws. I hope you found this helpful, and thank you for your time.